Here. All right. So as you heard during the introduction, my background is in law enforcement. So I've certainly seen landlord-tenant, complaints, disagreements from the law enforcement side of things. I was an investigator with the Bureau of Consumer Protection before taking this position. So I've seen how we at the state, mediate these complaints. And like most people, I've been a renter as well. So let's just jump right in and we have a little presentation here, and then there'll be plenty of time for some Q&A at the end. Or if you'd like, just throw those questions into the chat, and then we can circle back at the end and make sure that they all get answered. So just a quick little overview of what we do at the state. You may have heard of the Federal Trade Commission. So we're they're federal. At the state level, we very much do the same thing. We ensure fair business practices, prohibit fraud, deception in the marketplace. And what gives us the authority to do that is Wisconsin state statutes and administrative codes. And we're going to be talking about a couple of those tonight. We have a consumer hotline. That number is going to be up at the end of the presentation. We staff that Monday through Friday. 7:45 to 4:30. You can call us with, not only landlord-tenant questions, but anything related to consumer protection. And one thing that we really pride ourselves in is even if it's something that we don't have authority over, we're going to get you to the right state agency. It can get a little confusing of, whether it's Bureau of Consumer Protection or Department of Financial Institutions or Office of the Commissioner of Insurance or Department of Motor Vehicles on who handles some of these issues. But we'll get you to the right spot. We also have an outreach and education component, and that would be myself and another agency liaison, Francesca Johnson. Between the two of us, we handle all the outreach in the state of Wisconsin. We strive to do individually about 120 presentations each per year. So we're always looking to book more presentations, so keep that in the back of your mind while you're listening tonight of any opportunities that you'd look to have us back out. We have the mediation area. A lot of our landlord-tenant complaints start out in mediation. In fact, most all of our complaints start out in mediation. And then the more egregious violations can get moved down to the investigations department. And then from the investigations department, that's where reports can be referred up to district attorney's offices, Department of Justice. We have civil authority to look into these matters. We're not law enforcement. With like identity theft, we don't necessarily go after the criminals, but we have civil authority over administrative rules and state statutes that authorize us to do so. So here's a breakdown of some different types of complaints from 2020. Telemarketing is number one, probably better classified as scam phone calls. I'm sure a lot of people here have gotten scam phone calls at home or on your cell phone. You can see all of those complaints. But then number two on the list is landlord-tenant. We handle a lot of landlord-tenant complaints every year and work between the landlords and tenants to try to come to a satisfactory resolution. So some of those administrative codes and statutes that we're going to talk tonight about is Wisconsin Statute 704 and ATCP code 134. So 704 is kind of the all-encompassing state statute that deals with landlord-tenant practices. We don't have authority over 704, but a subsection of that, some of 704, has been created into administrative code through a rulemaking process, and that becomes that ATCP chapter 134. That is what we actually have authority over. And those fact sheets that were shared out in the chat, you can look at those and you can see a list of the differences between those two. So let's just jump into some of the different areas of 134. So leases. If you're going to be renting an apartment, almost always there's a lease. Almost always that's in writing, but it doesn't necessarily have to be. But if the lease is in writing, once you sign it, the landlord is required to give you a copy of that. Also under Chapter 134, receipts are required for any earnest money, security deposits, or rent paid in cash. Whether the tenant requests receipts or not, the landlord has to give a receipt if it's paid in cash. If rent is paid with a check, the landlord does not necessarily have to give you a receipt. The canceled check would end up being your proof, basically, that you paid. But you can still request a receipt in those situations. Landlord has to make disclosures. So they have to let you know who the landlord is and who the authorized agent is to pay your rent. It kind of makes sense. You got to know where to send your rent. And then before you rent, they have to disclose any code violations or habitability issues, anything that would make it uninhabitable. And this varies, county by county. Building inspectors get involved. Department of Safety and Professional Services for the state has building inspectors that also go out and inspect commercial buildings. And if a landlord is renting a place out, that's actually considered a commercial building. So check with your local building inspector for the last time that a building has been inspected and see if there's any code violations that you should be aware of. And then part of the lease also has to make a determination of who's paying for the utilities. And this one we just bring up in the presentation because we don't want people to be surprised. So you enter into a lease, and let's just say for easy math, it's $1,000 in rent, and you thought that covered utilities, and then you find out later on that it's another $200 on top to pay for the utilities. You definitely don't want that type of surprise. So make sure that is in writing in the lease of who's responsible for those utilities. So earnest money deposits. This is not exactly the same as a security deposit. This is the earnest money is money that you can pay down while the landlord is reviewing your application to decide to rent to you or not, and it basically holds that apartment for you. Again, if it's paid, or the landlord has to give you a receipt for that, they can hold it, and then within 3 days they have to decide whether they approve or decline your application. If they decline the application, they have to return the money. If it takes more than 3 days, basically they have to return the money, but you can enter into agreements that can extend that time out to, I believe, 21 days. The real trick is if the landlord accepts your application, and then after that happens, you decline to rent the apartment, there may be situations where the landlord can withhold that money for lost rent. And they have to give you an itemized list of that if they do withhold it. Not going into too much detail. This doesn't happen that often. Security deposits are a different thing. We're going to talk about that coming up. But earnest money deposits, there are definitely laws that regulate how that has to be handled. All right, speaking of that, security deposits. So during your check-in procedures, you may have a sheet of paper where you can document any damage that's in the apartments. It's always best to document. Take some pictures. But this is the administrative code, the 134.06, that most people are familiar with, where a landlord has 21 days to return your security deposit once you've vacated the apartment. So whether it was at the end of the lease and one side or the other gave notice to that they weren't going to renew and you moved out, or even if it was an eviction, once you vacated the apartment, that's when the clock starts. And basically the landlord has to return the security deposit within 21 days or give an itemized list of withholdings. And it's very specific what they're allowed to withhold for. Damage, not paying rent, money owed, are a few of the things. One of the handouts that I provided for this presentation is called the Landlord Tenant Guide. It goes into a little bit more detail of what they can withhold. The tenant responsibility is to make sure that the landlord has the correct forwarding address. Obviously, you just moved out of the apartment, so the landlord needs to know where to send that money to. And a lot of times, it can be just that simple, that no forwarding address was given. The landlord tried to return it, but didn't know how to get it back to the tenant. So that would be one of responsibilities of the tenant. Promises to repair. So we get a lot of phone calls at the state of issues with apartments once the apartment is occupied. So whether that be, black mold or, something stops working, that can get a little tricky once the apartment is occupied. But before the apartment is occupied, before you've moved in, if a landlord makes a statement that they're going to promise to repair something to induce you into signing the lease, that initial promise must be in writing, has to have a specific completion date. And we have authority to look into that matter. The landlord has to complete that repair on time. And then there's some exceptions on some legitimate reasons, lack of materials or weather, things like that could delay that completion time. But any promises to repair before you moved in writing, and we can look into that. Once the apartment is occupied, it can get a little bit more tricky. And give us a call at the state, and we can help you out with those types of situations and mediate those complaints. All right, these are some things that the landlord cannot do. So you can't have these items in the lease, or actually it can make the entire lease null and void. So, increase rent for, calling law enforcement or unlawful eviction procedures. There's only one way that a landlord can evict a tenant, and that's through the small claims court for the county that the apartment is located in. Acceleration of rent for failing to mitigate damages, requiring that you pay attorney's fees. You can kind of look at the list here. These are all things that cannot be in the lease. We don't actually see these very often because this is pretty well known that you just can't have that in the lease. Landlords obviously also cannot rent condemned properties, unauthorized entry. So this is the one that a lot of people are familiar with. Unless it's emergency repairs, the landlord has to give at least a 12-hour notice before entering the apartment. And as long as they give 12 hours notice, doesn't really specify how. So, if they call you, they just put something on the door. After that 12 hours is up, the landlord can enter the apartment. And it can be just for something they just want to do an inspection. It doesn't necessarily even have to have a reason. Automatic lease renewal without notice. Usually at the end of a one-year lease, there's a clause in the lease that it just automatically turns into a month-by-month agreement. You can't have a situation where it just automatically renews into a whole new year lease. Failure to deliver the apartment. So if you agreed upon a certain apartment, obviously that's the one that you get. Otherwise, that would be a violation. Late fees, rental penalties. This can get a little tricky. Everybody's situations are unique. So just give us a call at the state at that consumer protection hotline number, and we can help you out with this. Retaliatory evictions. So that would be like if in the winter the landlord turned off the heat or the electricity or the water in order to make the apartment unlivable. That is not allowed. Again, the only way that a landlord can evict a tenant in the middle of a lease would be to go through the courts. Or just the catch-all, if there's any kind of a misrepresentation. So terminating a tenancy, so the eviction. Right now, evictions can move forward with one exception, and that would be the CDC order that you may have heard about that prohibits a landlord from evicting a tenant for not paying rent due to COVID. And in order to have the protection under the CDC order from the federal government, the tenant has to fill out the federal declaration from the CDC website and present that to their landlord. Anything other than that, it's up to the county courts. If the courts are hearing eviction cases, those evictions can move forward. Ultimately, it's up to the county court. If a judge rules on a case, they are a higher authority than us. We cannot order a judge to change their ruling. That would be final. You'd have to go through the appeals process through the courts once there's a rule. So if there's a lease violation, such as not paying rent or anything else, the first thing that the landlord would have to do would issue what they call a 5-day right to cure. The tenant then has 5 days to either pay the rent or fix whatever was wrong or correct whatever violation there was. If they don't, then the landlord can issue a 14-day eviction notice and file that eviction with the courts. And then you'll receive paperwork from the courts, you'll receive service, and then there will be a court date and time and that you have to go to. There are resources out for that. If you do have a court date and you're looking for legal representation or ask a legal question, we're not lawyers. We can't give legal advice, but we do have phone numbers available to attorneys. And actually, because of COVID right now, there's a number of agencies out there that are waiving their normal fees. So some of them you can speak to an attorney for free for 30 minutes, which is usually enough time to get some of those legal questions out of the way. So you kind of understand and are better prepared for going to court. If you have a complaint against your landlord, that's kind of where we come in. So we handle complaints. Anything that I've listed already, or if there's anything that a landlord has done that you feel is in violation, we can certainly look into that. So we receive complaints, we analyze them, we look for violations of state law or administrative code that we have authority over. Usually the first step of our complaint process is to then send a copy of the complaint to the landlord with a letter from us on state of Wisconsin letterhead that detail any potential violations that we see. Even if we don't see any potential violations, we'll still send a copy of that complaint to the landlord and ask for a response within 2 weeks of what they're going to do about that complaint. And obviously, depending on what the landlord's response is, that'll kind of dictate the next step of the complaint process. So depending on how the complaint goes, and this is really hard to say on a case-by-case basis, but there's progressive enforcement, there's potential penalties. Our investigations department can get involved. District attorneys could even get involved for violations of state law, but usually we're able to handle it through the mediation process. I would say it's pretty rare that a case gets referred for what you see on the screen here: injunctive relief, restitution, civil forfeiture. But it's a possibility. So prior to filing a complaint, we recommend you communicate, see if you can work it out with your landlord, see, document everything, read over the lease. We can help you with that. Anytime you file a complaint with us, we always ask that the lease gets included as well, so that we can review everything. Document. If you have emails between you and the landlord, text messages that you can screenshot and send in. Basically, the more information, the better. We want to see everything, and then that helps us with our mediation process. So these are some of those publications I made available to you. The Landlord Tenant Guide is really nice. That's been included, tenants' rights and responsibilities, and then I even included the state laws and administrative codes if you like to read those, but it's a little complicated to read those sometimes if you're not. So if you are at a point where you do need to file a complaint, here's how to do it. Easiest way to do it is go to our website, www.datcp.wi.gov. If you don't have access to a computer, you can call us. Call that 1-800 number that I'm going to show you here in just a second. We can email you the complaint form, or we can mail it to you in the regular mail. We cover all of our bases. However, you can get a complaint back to us. We'll get that in our system, and we'll start working on that for you. If you do have to, and like I said, we do recommend that you send in the lease. If there's personal information on there, we don't need to see that. So you can go ahead and redact that information, block that off before you send it in. So if you go to our website, like I said, this is the easiest way to file with us. First thing you want to do is click on the consumer information button right there on the left side of the screen. That'll take you to this screen. And then there's a link right there that says file a complaint. Then it's going to show you all the different departments that are in my building. We're the third one down, consumer protection. I know there's a lot of clicks, but we can walk you through this over the phone as well. Once you click on consumer protection, you get to this screen and you can see all the different types of consumer protection complaints that you can file. Everything from door-to-door solicitations, home improvement practices, identity theft, there's landlord-tenant practices. We have authority over motor vehicle repair contracts, telecommunications, telemarketing, or, just a little bit right above that list, it just says to file a general consumer complaint, click here. That's always a good catch-all as well. And don't worry about this too much. All of the complaints go to the same place. So we can easily determine what type of complaint it is and get it classified in our system correctly. But if you click on landlord-tenant practices, that's going to take you right to this screen right here. I know you can only see part of it, but it's a pretty simple online form. Your information, as much information as you know about the landlord, and then there's a narrative box where you can type up the nature of what's going on, the nature of your complaint. I usually recommend typing that up in a like Microsoft Word type program, and then copy and paste it into the complaint form, just in case you type everything up and you hit submit and something glitches out with the system. I don't want you to lose all of that. Sometimes the stories are fairly long and there's lots of details in there. So type it up ahead of time, copy and paste it in there. And then once you hit submit on the next screen, that'll be the spot where you can upload a copy of the lease, those text messages, the emails, anything else related to the complaint. And then within just a couple of days, we'll get that assigned to a mediator. We'll review it for violations of state law or administrative code. And then you'll be kept up to date on what's going on with that. So we'll send you a letter. We'll send that off to the landlord as well. When the landlord gives the response, we'll send you the response for your review. And then, like I said, depending on that response, it'll kind of dictate where we go from there. Here's my information. There's the hotline, 1-800-422-7128. You can email our hotline as well. You don't have to just call them. You can email them at datcaphotline@wisconsin.gov, or just our regular website that I walked you through the process earlier to file a complaint. You can go there as well, and you can find all kinds of other fact sheets, not only related to identity theft, but other areas that we have authority over also. And with that, that kind of wraps up my landlord-tenant presentation. I'm going to leave this up on the screen here just for a second longer, but let me check the chat. I don't see any questions in there right now, but I'll give you a chance to get something typed in there if you have any specific questions. If it's real specific and you don't want to share in front of other people, certainly understand that. You can email me directly or call that hotline number tomorrow, and we'll certainly help you out with what's going on.
Yeah, so if anyone has any questions, feel free to type them in the chat, or I can unmute you too. Let me see if I can figure out how to do that. I don't see any questions coming in.
Well, I'll take that as a sign that we must have covered all the info. But
we do. We just have a question from Trudy. Yeah, Trudy is looking. Maybe could you talk about some examples of how you've helped?
Oh, sure. Well, I mean, I can't necessarily talk about like specific cases or anything like that, but there's lots of times that we've reached out to a landlord and shared a copy of a complaint and then mediated that between the landlord and the tenant to come to a resolution. Whether it's a repair that needs to take place or help a consumer get their security deposit back. Answering questions about, certainly in the age of COVID right now with some of the moratoriums on evictions out there, helping landlords and tenants kind of navigate that landscape. And a lot of people are interested in doing the right thing. They just, it can get confusing, 5-day notices and 14-day notices and 28-day notices to vacate. And we're here to kind of help out both sides, navigate that. And I think we do a pretty good job with it. I talk about landlords collaborating to blacklist tenants. Well, I'm sorry to hear that that's a real problem in Superior. I'd say reach out to us and we can certainly look into that. I I'm I don't have any inside information on that, but I mean landlords are allowed to uh, do background checks. But if somebody is being discriminated against and they're not renting to somebody, based on something where it's discrimination. Like I said, that might not be something that we have authority over, but the Wisconsin Department of Workforce Development can look into housing discrimination. And then we don't have financial support for tenants for legal fees, but we do have lots of phone numbers, and we can point you in the right direction to talk to some of those attorneys for free for at least up to 30 minutes. And then I think some of them it's only like $20 for each half hour. So some very discounted services. And then it depends on what county you're in, what else might be available. I'll be honest, I'm not sure exactly what's up in Douglas County, but for services. But I've got in the other room, I've got a book that we call the Ready Reference Guide that has all kinds of resources in there. We can get you pointed in the right direction.
I hope that answers your questions, Trudy. Thank you. Any other questions that we have for Jeff? Oh, looks like there's one more question. How do you work with housing services like HRA?
So I'll be Superior Housing Authority. So that sounds like something at like the city or the county level. I don't know necessarily if we do work with them directly, but yeah, I mean, I'll be honest, you caught me off guard on that one. I'm just not familiar with that agency, but um, yeah, we certainly could work with them.
All right, any other questions for Jeff? We did record this presentation, so I'll be sending an evaluation out this week, and I'll be able to provide the link to the presentation if you wanted to rewatch it or if you missed something. I'll also send the handouts again too, so you'll have those in a couple different places, hopefully. So, but if there aren't any other questions, Mary's responding. She is with the SHA, the Superior Housing
Okay.
Authority. Maybe a good resource for our voucher clients. Thank you,
Excellent.
Mary. All right. Well, if there aren't any other questions, I think we can wrap up. Thanks to everyone for joining us. And thank you so much, Jeff. This was so informative and so helpful. And hopefully we can bring you back, hopefully in person for another presentation once it's safe to have people get together again. So thank you so much.
Absolutely. Hey, thanks so much for having me.
Well, have a good night, everybody.
Thank you. Bye bye.
Bye-bye.